Welcome back to Organized, the business law breakdown. I'm Seth C. Orenberg, and today we're going to be tackling one of the fundamental questions of contract law. Who has the legal capacity to form a contract? Imagine this. What if someone wasn't able to understand a deal they just made? Can they walk away from it? Today, we'll dive into the rules that decide who can legally make a deal and who can't. In our previous episode, we talked about promises, what makes them binding and enforceable in court. But promises only matter if the person making them has the legal ability or capacity to do so. In today's episode, we'll explore what happens when a person is a minor, dealing with mental illness, intoxicated, or under guardianship. These situations can make a huge difference in whether or not a contract is enforceable. We'll look at real-world cases like Webster Street Partnership versus Sheridan, where a minor tried to disaffirm a contract after reaching adulthood, and break down some hypothetical problems to show how law treats different scenarios. So, if you've ever wondered what happens when someone signs a deal they aren't legally capable of making or understanding, stick with me. We're about to break it down. When we talk about legal capacity, we're asking a critical question. Does this person have the ability to understand the nature and consequences of the contract they're entering into? It's not enough just to sign on the dotted line. For a contract to be enforceable, the person signing must have legal capacity to understand what they're agreeing to. Let's break this down into a few key categories where capacity is a major issue. First, infancy, or as we more commonly say, minority. Contracts with minors are considered voidable by the minor. This means that while minors can enter into contracts, they can later choose to disaffirm them. Why? Because law assumes that minors don't have the experience or maturity to fully understand the obligations of a contract. However, there's an important exception: necessaries. If the contract involves necessaries like food, clothing, or shelter, a minor may still be held liable for the value of those goods or services. Next, let's look at mental illness. A person who suffers from a mental illness may lack the capacity to form a binding contract if they can't understand the nature and consequences of an agreement. Courts evaluate this on a case-by-case basis, using the Restatement Second of Contract, Section 15, which explains that a contract is voidable if a person is unable to comprehend what they're doing due to a mental disorder. Then we have guardianship. If a person is under legal guardianship, they generally don't have the capacity to enter into contracts on their own. Let's break this down into a few key categories where capacity becomes a major issue. First, we have guardianship. If a person is under a legal guardianship, they don't have capacity to enter into contracts on their own. In these cases, the guardian who is appointed to act on their behalf must act on their behalf. Any contracts entered into the individual without the guardian's consent during the period of guardianship are typically considered void and unenforceable. Second, infancy, or as we usually say, minority. Contracts with minors are considered voidable by the minor. This means that while minors can enter into contracts, they can later choose to disaffirm them. Why? Because law assumes that minors don't have the experience or maturity to fully understand the obligations of a contract. However, there's an important exception: necessaries. If the contract involves necessaries like food, clothing, or shelter, a minor may still be held liable for the value of those goods and services. Third, let's look at mental illness. A person who suffers from a mental illness may lack the capacity to form a binding contract if they can't understand the nature and consequences of the agreement. Courts evaluate this on a case-by-case basis, using the Restatement Second of Contract, Section 15, which explains that a contract is voidable if a person is unable to comprehend what they're doing due to a mental disorder. Fourth, we'll talk about intoxication. While it may seem obvious, if a person is too intoxicated to understand the nature and consequences of a contract, and if the other party is aware or has reason to be aware of that level of intoxication, the contract is generally voidable by the intoxicated party. But the key here is proving that the intoxication was severe enough to affect their judgment and that the other party had reason to know of that level of intoxication. Courts are reluctant to void contracts based on intoxication unless there's clear evidence the person couldn't have understand what they were agreeing to and the other party was aware of this. These categories, infancy, mental illness, guardianship, and intoxication, help define who has the legal capacity to form binding contracts. If any of these conditions apply, a person may have the right to void or cancel or disaffirm an agreement. Understanding capacity is crucial because it ensures both parties are entering into agreements with full awareness of their obligations. Let's break it down by looking at the case of Webster Street Partnership Limited versus Sheridan. This case is a great example of how law treats contracts made by minors and the doctrine of disaffirmance, which allows minors to avoid contracts under certain circumstances. Here's the brief situation. Sheridan, a minor, signed a lease with Webster Street Partnership Limited to rent an apartment building. After turning 18, the age of majority, he continued living in the apartment for a few days, moved out, and tried to disaffirm the lease, arguing that he wasn't bound to the remainder of the contractual term and that he didn't have to pay for the time he stayed there because he was a minor when he entered into the contract. The key legal question was whether Sheridan could avoid the lease after reaching adulthood. Under the doctrine of disaffirmance, minors can generally void contracts they entered into while underage, and they must do so promptly after reaching the age of majority. So they can disaffirm contracts after turning 18, but they have to do so promptly. Sheridan's case hinged on that fact because he vacated the apartment about 7 days after turning 18, and the court determined this was a reasonable time frame to disaffirm the lease. The case illustrates the voidability of contracts with minors and shows how courts give minors a limited time after reaching majority to disaffirm a contract. The law assumes that minors lack capacity to fully understand the implication of long-term contracts, which is why they're allowed to walk away from such deals briefly after they come of age. Now, let's not forget the important exception to this rule, necessaries. If the contract is deemed for something that is necessary, like food, shelter, or clothing, the minor may still be liable for the reasonable value of those goods and services, even if they attempt to disaffirm the contract. In this case, the lease for an apartment could fall under the category of a necessary because it involves shelter. But Sheridan uniquely had the ability to go home. He had an alternative, so he did not actually need, in his case, this apartment lease in order to survive, and therefore it was not a necessary as to him. The takeaway here is that while minors can void contracts, the law also protects businesses, such as landlords, by requiring minors to act promptly once they reach adulthood. Additionally, when the contract involves necessaries, the minor can still be held responsible for the value of what they received under the contract. With that case in mind, let's imagine how these rules might play out in different situations. Let's play out a more detailed what if to explore how the courts determine whether something qualifies as a necessary. Let's play out a more detailed what if to explore how courts determine whether something qualifies as a necessary for a minor. This is a fact-specific inquiry, meaning what is necessary for one person may not be a necessary for another. Let's work through 3 examples to see how this plays out. Imagine a minor buys a brand new luxury sports car with a financing. So they pay overtime, make a promise to pay overtime. A few months later, they decide they don't want the car anymore and try to disaffirm the contract, arguing they didn't have legal capacity to make the purchase. So here's the question. Is the sports car a necessary? The answer is almost certainly no. A sports car would be considered a luxury, not a necessary for daily life. The law protects minors from making these kinds of extravagant purchases by allowing them to void contracts for non-necessaries. In this case, the court would likely allow the minor to disaffirm the contract without holding them liable for the car's value. Now let's change the facts a bit. Imagine instead that the minor buys a basic, affordable car. And further, the minor lives in a rural area with no public transportation, and they need the car to get to work and buy groceries. In this situation, the car could be considered a necessary. Here's why. This car is essential for this minor to maintain this livelihood and access based on needs to get food and work. Since the law treats necessaries differently based on a fact-specific analysis, the minor might be responsible for paying for the reasonable value of the car, even if they try to disaffirm the contract. The court could rule that transportation is essential in this specific context of a basic car for a rural minor. And let's tweak this situation one more time. Imagine a minor buys a basic car, but this time the minor lives in an urban area with plenty of public transportation options. Here, the court might decide the car is not a necessary because the minor has alternative means of transportation, like buses or trains, to get to work or school or the grocery store. In that case, the court would likely allow the minor to disaffirm the contract, reasoning that the car wasn't essential to daily life, unlike the rural example. Let's shift gears and look at a different type of capacity issue, one involving mental illness. Let's break it down with another important scenario. What happens when a person suffers from mental illness and enters into a contract? This brings us to problem 2.2 in my casebook, where Stanley Fingerhut tries to rescind a contract due to his bipolar disorder. The question here is, did Stanley have the legal capacity to enter into a contract during a manic episode? Under Restatement, Second of Contract, Section 15, a person lacks contractual capacity if, by reason of mental illness or defect, they are unable to understand the nature and consequences of the transaction or are unable to act rationally in relation to the transaction. In Stanley's case, he signed a contract during a manic episode, which severely affected his ability to make rational decisions. Courts generally evaluate these situations by looking at whether the person at the time of contracting was able to comprehend what they were agreeing to. If the mental illness prevented their understanding, the contract could be deemed voidable by the person suffering from the illness. What makes mental illness cases particularly challenging is that courts have to assess the person's mental state at the time the contract was signed. In Stanley's case, his bipolar disorder may not make him legally incompetent all the time, but the court could find that during the manic episode, he lacked the ability to understand or control his actions. This case highlights the complexity of determining contractual capacity for individuals with mental illness. Unlike minors, whose incapacity is easily established based on age, mental illness requires a much more fact-specific inquiry. Courts must carefully assess whether the person understood the nature and consequences of the contract when it was formed. We've looked at mental illness in contracts. Now let's see how intoxication might impact the ability to make a deal through a well-known movie example. In the movie The Hangover, one of the most famous scenes is when the characters wake up after a wild night in Las Vegas, only to find out that one of them, Alan, got married while heavily intoxicated. This situation illustrates the idea of intoxication affecting legal capacity. Could Alan really have understood the consequences of getting married or entering into any significant contract for that matter while he was that drunk? I have a similar case in my casebook, problem in my casebook, which asks whether a gambler who is basically dead drunk and borrows $1 million to continue gambling is responsible for that as well. In real life, contracts are made under heavy intoxication, and they could be voidable because of that intoxication. The law recognizes that if someone is too intoxicated to understand what they're agreeing to, the contract might not be enforceable. But again, there's the key element that the other party, the other side of the contract, needs to have reason to know of this intoxication. We don't want to let people off the hook for making drunk agreements too easily, and we want to protect both parties. And so the law strikes a balance by having additional requirements before we allow someone to avoid a contract for intoxication as compared to mental illness. Before we finish, let's take a quick look back at what we've covered. Let's recap what we've covered today by discussing the concepts of capacity to contract. We highlighted that not everyone has the legal ability to form binding contracts. Whether due to guardianship, infancy, mental illness, or intoxication, a person may lack the capacity to fully understand the consequences of a contract and therefore may not be obligated to follow through on their promises thereunder. We looked at the case of Webster Street Partnership versus Sheridan, where a minor tried to disaffirm a contract after reaching adulthood. This taught us that while minors can void contracts, they must act within a reasonable time frame, and they still may be liable for necessaries like shelter or food. Our what if segment showed how the definition of necessaries depends on the facts. What counts as a necessary for one person may not be for another. A sports car is rarely a necessary, but a basic car might be if a minor lives in a rural area without access to public transportation. And we explored mental illness and intoxication in contracts, using a scenario where a person's bipolar disorder during a manic episode may have affected their capacity to make a binding agreement. And we turned to The Hangover, where a character's drunken decision-making illustrates how intoxication can impact the ability to form enforceable contracts. Before we wrap up, take a moment to think about the concept of capacity. When might this come into play in your work or life? Have you ever been involved in a contract where one of the parties lacked the capacity to fully understand what they were agreeing to? How did this affect the outcome? If you have questions or comments about today's episode, or if you have your own what if scenarios, I'd love to hear from you. Put your feedback in the chat below and we'll continue the conversation. Your feedback helps shape future episodes, so don't hesitate to reach out. And don't forget to subscribe, leave a review, and share this podcast with others who might benefit from these discussions. Next time, we'll explore bargains, and we'll talk about how contracts applies an objective theory to understand how the world sees a contract as opposed to a subjective theory that involves getting into people's heads. That's all for today's episode of Organize, the Business Law Breakdown. I'm Seth C. Orenberg, and I appreciate you tuning in to learn about the legal contract. Next time, we'll explore the concept of bargains, and we'll talk about how bargains are evaluated objectively. And we'll relate this objective theory of contract to understanding what a reasonable person would believe about a situation that unfolds. Stay tuned for that. But for now, that's all for today's episode of Organize, the Business Law Breakdown. I'm Seth C. Orenberg, and I appreciate you tuning in to learn about the legal concept of capacity. Until next time, keep your agreement strong and your argument stronger.